Evening, everyone. My name is Angel Burgess, and I am pleased to be here with you all today to talk with you about narcolepsy and disability, how to strike a balance between physical and emotional health. Now, this topic is really important to me because as a disability attorney, these are issues that I encounter every day. And I've found over the years that one of the biggest hurdles to a disability claim is the emotional aspect of it and making the decision that, yes, it is time for me to apply for disability. Now, why is the emotional aspect of disability so important? I think it's because there's a stigma associated with the word disability or the word disabled. And a stigma is it's essentially a mark of disgrace that is placed or associated with a certain term, like disabled or disability. And that stigma exists, I think, for a few reasons. I think that society kind of places or associates a negative thought with disability or being disabled. And quite frankly, I think most people don't know what it really means to be disabled. It doesn't mean that you're bedridden, it doesn't mean that you can't be productive, but society tends to have this view of disability. And so a lot of people are reluctant or flat out refuse to pursue disability benefits that they need because of the stigma that's associated with it. The problem with the stigma is that it prevents us from getting the things that we need. It prevents us from seeking treatment, from asking for help. It prevents us from collecting and retaining documents or other things that we will need to prove that we're having a difficult time with work. The stigma prevents us from requesting accommodations. And sometimes accommodations in the workplace or at school can be the difference between you being successful on the job and getting fired. But because of the stigma, a lot of people are hesitant to ask for the help that they need. The stigma also encourages people to resign from jobs or withdraw from school when there may be other avenues available to them. It also prevents people from filing for benefits that they need, such as short term disability or long term disability, or in some cases, Social Security disability. How do we debunk the stigma? How do we change our mindset around the words disability or disabled? Part of the issue is what we see on TV or what we read in the paper. And that tends to be this view that, people that receive disability benefits are scamming the system or, they're not as disabled as they present themselves to be, that they're trying to take advantage of a system. And that's just not the case. The Social Security Administration has actually studied and greatly invested time into looking into things like, how much fraud is associated with disability claims. They have found that less than 1% of people are committing fraud against the Social Security Administration. So that tells us that most people who are receiving these benefits are receiving them because they need them. The other thing about the stigma is that being disabled doesn't mean that you are necessarily unable to work at all. What it means is that you're unable to work at a substantial level, which we'll talk about a little bit later. But there are many people who receive disability benefits and are able to do some work, and the rules allow for that. But again, because of this stigma, a lot of people don't understand exactly what it means to be disabled. The Social Security Administration has also done studies over the years trying to figure out, okay, what happens when people are denied disability benefits? So let's say, you go through the process, you get denied. What happens to those people that get denied? And a study that they did a few years back had some really interesting results. In that study, they found that almost 25% of people that had been denied by a judge, which is the level where most people will stop, but almost 25% of the people who had been denied by a judge 4 years later were still out of work. So it wasn't one of those situations where they said, okay, well, if I don't get disability, I'm just going to go back to work. They weren't able to. That same study showed that roughly 12 to 15% of those people that had been denied were able to return to work in some capacity. So, time, some were only able to return part time. But that is a small percentage of the people that had been denied. And there were also individuals in the same study that appealed beyond the judge level and they got approved for disability benefits. There were people that just filed a brand new application and got approved for benefits. So, the important thing I think to take away from that study is that it confirms the belief of people who really know what it means to be disabled, and that is that people apply for disability benefits when they need them, when they're no longer able to work at a level that is going to be sufficient. Another thing that's important to know about disability benefits, particularly with Social Security disability benefits, is that they don't broadcast the fact that anyone is receiving disability. In fact, it's private. Your information is kept private by the Social Security Administration. Your neighbor can't go look it up and see if you got approved for benefits. Nobody knows but you and employees of the Social Security Administration. So, a lot of people will say to me, well, I don't want anybody to know that I'm disabled. I don't want anybody to know that I'm not able to work anymore. And they don't have to know that. That is completely up to you in terms of how much information you divulge to other individuals. But the Social Security Administration is not going to put that information, out there. And importantly, most importantly, I think it's important to recognize that you ultimately decide what it means to be disabled or what disability means. So, Social Security has their definition and there are things that they have to prove or that you have to prove in order to get the benefits. But beyond that, what you do with your life, what you find joy in is completely up to you. It's important to change your mindset. Anything that you have thought about disability in the past, or that a family member has told you, or that the media has told you about disability, change that mindset. Understand that you need to be your best advocate. You need to make sure that the services that you need, the treatment that you need, the financial support that you need, you pursue those things. You make sure that you get the things that works best for you. And part of that is learning about disability programs, learning about your options. And hopefully, many of you who are with me today are at a place where, maybe you're still working and you're having difficulty, on the job or difficulty in school. And there are some options that are available to you or that may be available to you at this point that you may be able to pursue without necessarily filing for Social Security disability. So I do want you all to know that there are other options available to you if you are currently working and you're in a place where you're having difficulty doing your job. Make sure that you ask for what you need to become your best self, to get access to your treatment, to make sure that you're able to keep that job. Your employer may accommodate you. Your employer may be flexible. Your school may be flexible in helping you to get additional resources so that you can stay in school or that you can keep your job. Do what's best for you. So reset your expectations. Dealing with narcolepsy can be devastating. It can be debilitating. Um, and sometimes it's important to figure out, okay, these are the limitations that I have. Now, what is it that I am able to do? Or what am I going to do within the confines of these limitations? Find your purpose. Do things that make you happy. Know that there are other people who are in the same situation that you're in, and use each other as a resource. Seek advice. They've been through the same thing that you're going through right now. I know that in the sessions this weekend, there have been support groups. Lean on support groups because people with shared experiences can be your greatest asset. Help someone else. If you're in a place where you've been able to get accommodations from work or you've been able to receive disability benefits, help someone else and kind of share your experiences with them so that they have another perspective from someone who knows exactly what you're going through. Now I want to turn to the physical aspects of disability and talk about disability programs that are available. Now, many of you have heard about these programs, and in most cases, there are three different types of programs which are available. There is short-term disability, long-term disability, and Social Security disability. Now, I do want to say that the short-term disability and long-term disability benefits are available to people who are working. So these benefits may be available either through your employer's sponsored plan, or you may be able to purchase a private policy for short-term disability or long-term disability. The goal is to have as much of your income as is possible when you're not able to work. So let me give you just a quick example. If you are having difficulties managing your symptoms and your employer offers short-term disability and long-term disability, instead of resigning from your job or even possibly being terminated from your job because you're not able to do your duties, look first to short-term disability and then to long-term disability. So you may be able to utilize these benefits and still get a portion of your salary while you're out of work. And if you don't expect that you are going to be able to return to work because of your symptoms, then of course that's where Social Security disability will come into play. And Social Security disability is really my specialty. I don't specialize in the short-term and long-term disability benefits, but I just wanted you all to know that they are available to you, or that they may be available to you, and that you should talk with someone in human resources about any potential benefits before you take any drastic steps like resigning from your job. Now, Social Security disability is the program that most people have heard of. And these benefits can be available to people who have worked, and they're also available to people who have never worked, as long as you meet certain financial requirements. So the Social Security Administration says, in order to be disabled, you have to prove that you have the inability of engaging in any substantial gainful activity, And substantial gainful activity for 2021 is basically making $1,310 per month gross. So if you're unable to make $1,310 per month because you have a physical or mental or a combination of physical and mental impairments, and these impairments can be expected to last in death or can last or be expected to last at least a year, and these conditions keep you from performing gainful employment. Now, the Social Security disability process is typically lengthy. And so most people that do get approved for disability benefits have to go through a three-step process. The first step, which is the hardest step, because that's the step where you are saying, okay, I need these benefits. I'm going to go ahead and apply for the benefits. That's the initial application phase. And during that phase, Social Security is going to get information from you about your medical providers, who your doctors are, what medications you're taking. They are going to request and review those medical records. And then Social Security has their own doctors. So they have their own medical doctors and they have their own psychologists who will review the medical records, and they make a decision about whether or not they think that you meet the definition of disability. Now, at this level, approximately 25 to 33% of people who do get approved will get approved at the initial level. It can take 3 months to over a year to get an initial decision from Social Security. If you get denied, then you're going to appeal that denial. And the next step is called reconsideration. With the reconsideration step, what they're doing is they're getting updates from you. So medical updates, educational updates, any sort of updates that you have. And they are going to take another look at your medical records. So a fresh pair of eyes are going to review the updated information, and they are going to see if they were wrong the first time. If there's anything new that causes them to say, you know what, this person is disabled. Statistically, it rarely happens. Most times, 90 to 93% of the time, Social Security is going to say, you don't meet the definition of disability. We were right the first time when we denied you. So from that point, you're going to have to file another appeal. And that next appeal is requesting a hearing. The hearing level is where most people that get approved for disability find success. And at the hearing level, you are going to a hearing with an administrative law judge. And the administrative law judge does a brand new and independent review of the medical evidence. So they are not bound by the previous denials that you received. So they take a fresh look at everything. The judge also has the opportunity to ask you questions, to get more information about the things that you're dealing with on a day-to-day basis. And there is also a vocational consultant involved at the hearing level, an expert who will testify about work limitations and how those limitations could affect your ability to work. So most people that apply for and get approved for disability benefits, like 65% or so, are going to get approved once they've seen a judge. Now, getting to a judge can take a year, it can take 2 years or more, because you have to get denied at initial, get denied at reconsideration before you can have your hearing with the administrative law judge. And the COVID-19 pandemic has undoubtedly skewed these estimates a bit. And so, these days, it can take much longer to get through the initial and reconsideration levels. because a lot of the offices that will do a physical or a psychological exam are closed or are just now starting to see people virtually. So that has had a significant impact on the wait times for disability claims. So, how do you prove the severity of your narcolepsy? You know that there's this process involved, you know that you need to get medical evidence, but beyond that, how do you prove your claim? The first and most important thing is that you have to have documented support for the narcolepsy, for your symptoms. What Social Security is going to do is they're going to look at those medical records. They're going to look to see, okay, do we have a diagnosis of narcolepsy? If we do, how did the physician arrive at this diagnosis? You know, were there sleep studies? Were there reports of cataplexy? You know, they will look at a variety of factors to see how the diagnosis was determined. And so they are looking to see, how does the narcolepsy affect you on a day-to-day basis? The diagnosis of narcolepsy alone is not going to get you approved for disability. You have to prove that the narcolepsy and the associated symptoms are so severe that they keep you from being a reliable employee, that you're not able to be competitively employed. So, talking to your doctor is essential. Explaining things like sleep times, the frequency of naps, how well or how much difficulty you have in responding to the medication. All of those things are very important for your doctor to know to help to treat you, but also for Social Security to know, because that helps them to figure out if you're able to manage your symptoms with medication. If you're having any side effects, that's something that needs to be communicated to your doctor, and that will also be in your medical records. It is very helpful because narcolepsy is not, a really well-known condition. It's helpful to have a statement or a letter or a questionnaire from your physician that explains the disorder, that explains your symptoms, and how you are responding to treatment. So now that you have some documented support for the diagnosis, for the symptoms that you're having, how do you prove that you're unable to work? If you have worked or are currently working, employment records can be very helpful. If you're having difficulty, staying awake on the job, if you've been disciplined, if you've received any written warnings, if you've received verbal warnings, if there have been any sort of email communications between you and your supervisor about your job performance, that can be really good evidence to Social Security that I'm working, I'm having problems doing my job, and my supervisor is recognizing that I'm not doing what I'm supposed to do. If you have attendance records, if you are terminated, sometimes, believe it or not, employers will, in the separation notice, they may say something like, health problems are keeping her from doing her job, or she was absent too often due to her health issues. That can be good evidence for a disability claim. If you've never worked, and let's say you're a student, school records can be helpful. If there are any 504 plans or IEPs or teacher evaluations, particularly when we're talking about children under the age of 18, the school records can be helpful in proving the severity of the narcolepsy. Disciplinary reports, emails from teacher to parent about, I'm having difficulty getting your daughter to understand the subject matter because she's napping so much during class. Things like that can be helpful to demonstrate that the severity of the narcolepsy is interfering with their functioning. And most importantly, stay encouraged. Um, you know, understand that disability, whether it's through an employer sponsored plan or through Social Security disability, these benefits are here to help you to, maximize your functioning, to access the resources that you need to live a better quality of life. The unfortunate thing about the disability programs is that they're not just handing out benefits to anyone. It's difficult to get approved, as many of you may know. And so, the most important thing to know about applying for disability is that if you get a denial, continue to push forward for as long as you think that you are not able to work. So if you feel that you are disabled, that you are not able to work, don't give up because you got a denial. Continue to push forward and appeal, and just try to get the result that you're looking for. Try to get the help that you need. So, with that, I appreciate everyone's time and attention, and we are going to take questions. So, the first question that I see here asks, is it too late to apply for disability insurance? I haven't worked since I had my children in 2005. I wasn't diagnosed until 2013, but I was unable to return to work due to narcolepsy symptoms and other comorbidities. So, this is a great question. With Social Security disability, there are two programs. So, one program is traditionally known as the Workers Program. It's called the Disability Insurance Benefits Program. And so, this program provides benefits primarily to people who have worked and paid into the system. In your case, since you haven't worked since 2005 and you weren't diagnosed until 2013, it would probably be very difficult for you to get disability benefits through that program. But I said probably, so not necessarily impossible, but you probably have to prove that you became disabled and unable to work, I'm guessing by 2010. So, what I would suggest to you is to contact the Social Security Administration and ask them what your date last insured is. And your date last insured will tell you this is the cutoff date in terms of proving that you became disabled. So if they say your date last insured is December 31st of 2010, that means you have to prove that you became disabled and you met the requirements on or before December 31st of 2010. So it will be somewhere between 2005 and December 31st of 2010. That's going to be your window to prove that you became disabled and unable to work. Now, because that was, over 10 years ago, you'll need medical evidence. If you have medical records from that time frame, then you may be able to prove that you became disabled back then and thus eligible for benefits. If you don't, then benefits through that program are going to be very unlikely for you to be able to get because you're not going to be able to prove disability. However, there is the other disability program called SSI, which is Supplemental Security Income. Now, SSI benefits are available to people whether or not you've worked. So you may qualify for SSI, but you have to meet certain income and asset requirements. So if you have excess resources, so let's say, you have, just for sake of example, let's say you have a 401k and you've got $20,000 in your 401k. Then you're not going to qualify for SSI. Or let's say you are married and your spouse makes $60,000 a year, then you're not going to qualify for SSI because for SSI, you have to show very limited assets and resources. So I hope that that answers your question. And for any of these questions or any other questions that you all have, you can feel free to contact me and I'll be happy to talk with you about it in greater detail. So the next question, it just says Family Leave Medical Act, and I think you're referring to FMLA. So FMLA, and I'm just kind of guessing what the question is, but you may be able to, depending on the size of the employer and how many employees your employer has, you may be able to take leave under FMLA, but that leave is probably not going to come with any sort of financial benefit. So you may be able to go on leave, unpaid leave for a period of time, but again, that doesn't give you any financial support, and the FMLA isn't going to be indefinite. So if you have specific questions about the FMLA benefits and whether or not you're covered under your employer, then I would suggest reaching out to your human resources department to get more information about that. If you work for a small company, then there may be some issues there with having the benefit of FMLA. The next question says, how does SSDI work for children? Should a parent of a disabled child apply for SSDI? So there may be two different ways that you're asking this question. If we're talking about a child under the age of 18, then that child is going to possibly qualify for SSI, not SSDI. So SSDI is the workers program. And if your child has never worked, then they're not going to qualify for that as a minor child. But if we're talking about a minor child, they may be able to get benefits under SSI. And so SSI is, again, an income and asset-based program. So let's say that you have a 7-year-old with narcolepsy, but you make $80,000 a year. Then your child is not going to qualify for SSI. But if you make $20,000 a year, depending on your other resources, then your child may qualify for SSI. Now, the rules for disability for children are different than the rules for adults. So for children, Social Security is looking at the severity of your child's symptoms as compared to children that do not have narcolepsy. So they are trying to figure out how the narcolepsy and the associated symptoms affects your child in several domains of functioning. So it is possible to get benefits for a child under SSI if your income and assets fall within the guidelines. The next question is, what if you were denied at all stages, including a hearing? The judge tells you your income prevents the ability to approve disability. So that could be due to a couple of reasons. If you have income because you're working, so let's say sometimes people will apply for disability benefits and they're working full time, you're not eligible. Or they may be working part-time, but they are making more than $1,310 per month, then most likely you're not going to be eligible for disability benefits. So there really wouldn't be any additional avenues for you to pursue if your income is too high to allow you to meet the definition of disabled. The next question asks, do you need an attorney to go through the application process? It's a great question. And it's similar to another question that I see here that says, I have applied for disability with the help of a lawyer. Is that worth it? So, putting aside the fact that I'm an attorney, I am going to say it is absolutely worth it. And let me tell you why. As a lay person or a lay individual, there's no reason that you would have any knowledge of Social Security's rules and regulations. One of the biggest factors that I see for denials, people will come in, they'll say to me, my child was denied or I was denied for disability benefits, and I can't understand why. I've got A, B, and C. Sometimes it's a technical issue. It's you have too much income, or you didn't apply for the right type of disability benefits. Um, Also, being able to have the expertise to help you navigate through the process, to prepare you for a hearing, to make sure that Social Security has all the medical evidence that they need to make a good decision in your case. That's where an attorney really comes into play, is making sure that all of the evidence to present your case is there for Social Security. And as attorneys, that's part of our job. We case to the judge. And presenting your case means making sure that you understand what the rules are, making sure that you understand what to expect, and that you're prepared for the hearing. Any legal proceeding, I would I would not involve myself in any legal proceeding without having the expertise of an attorney there. With that being said, it is completely optional. You can go through, and some people apply for benefits and are successful on their own. So there is no requirement to have an attorney for a disability claim. But for something that's so important as, making sure that you have health insurance and making sure that you have financial support, I think it's prudent to have an expert to guide you through that process. And I think that's going to give you your best chance of success. Now, along the lines of those questions, attorneys are paid on a contingency basis for disability claims. So we're not paid like typical attorneys, right? Typical attorneys would say, okay, you have to pay a retainer of X amount, and then my hourly rate is, $250 an hour. Well, disability attorneys, Social Security disability attorneys, I should say, we don't work that way. Social Security actually regulates how we're paid, and they are actually the ones that pay us. So their rules say that in order for us to get paid as your attorneys, we have to win your case for you. Not only do we have to win your case for you, but you also have to be entitled to past due benefits. And earlier I talked about how long the process can be and usually is. And so because that process is usually so long, most people are entitled to past due benefits. And if both of those conditions are met, then Social Security will pay the attorney out of your past due benefits. And they will pay the attorney 25% of your past due benefits with a cap of $6,000. So if you go through a disability case, your attorney helps you to get approved, and Social Security comes back and says, we owe you $10,000 in back pay. What they're going to do is they're going to pay your attorney 25%, which is going to be $2,500. But the most that your attorney will ever be paid is $6,000. The least amount of money that your attorney will ever be paid is zero. So that's how it works with a lawyer. The next question says, what would be your recommended course of action for disability for pregnancy? And I'm not sure if you are referring to short-term disability, long-term disability, or Social Security disability. If you are referring to Social Security disability, and the question is, how do I proceed with my claim when I'm pregnant? I would say you proceed with your claim in the same fashion that you would if you weren't pregnant. Now, the difference often is that there may be some modifications to your medication because of the pregnancy. So what Social Security would look at that point in time is before the pregnancy, how are you responding to medications? If the medications were adequately managing your symptoms before the pregnancy, and then let's say now you've had to stop taking a key medication during the pregnancy, then the expectation that Social Security has is going to be that that issue is not going to last for a year or more because the pregnancy isn't going to last for a year. And so that would be more of a short term disability issue than a Social Security disability issue because you won't have that 1 year duration. But you may have some potential benefit that you can get from short term disability. So you would go through your employer and perhaps hire a short or long term disability attorney to help you with that claim as well. The next question asks, it says, I was denied federal medical retirement because I would become cataleptic every time I tried to fill out the paperwork. I got the paperwork in almost a month late. I tried to get help from my congressional representative, but he wasn't interested in helping me. This was 6 years ago. Can I get help? I can't speak to the federal medical retirement program beyond saying that it would probably be most helpful for you to reach out to an attorney that handles federal the FERS program is what they call it. So I would suggest that you reach out to an attorney to see on that side of things whether you have any course of action because it has been 6 years and I'm not sure that you will. But again, that's not my area of expertise, so I don't want to give you an incorrect answer. The next question asks, spousal divorce an option for spouse preventing eligibility? So I'm not exactly sure what this question means, but I'm going to answer it in the way that I'm interpreting it. I think you're asking if you get divorced, would you be eligible for disability based off of your ex-spouse's earnings record? And the answer to that is it depends. It depends how old you are. So if you and your ex-spouse are in your early 60s and you've been married or you were married for at least 10 years, then possibly you may be able to get some benefits based off of their work record. The next question asks, it says veterans disability options, and I just want to touch on this briefly. So veterans disability is a completely separate program from Social Security disability. Veterans disability and the option to receive benefits through the Veterans Administration is based off of conditions that are related to your service, your military service. So you may be able to get disability, veterans disability, and you may also be able to get Social Security disability for those same conditions, but their rules are completely different. So the VA is more concerned with, do you have a service-connected disability? If so, you may be able to receive compensation for it. The Social Security Administration is concerned with, do you have a condition, doesn't matter if it's service-connected, when the condition started, But do you have a condition that keeps you from being able to work full time and competitively because of the severity of that condition? So, two completely different programs. You may be able to receive benefits, though, for both as a veteran, and thank you for your service. With that, ladies and gentlemen, I believe that we are out of time. But if any of you have any further questions, please feel free to reach out to me, and I will just quickly type my office number in the chat and my email. Thank you all. I hope that you have a wonderful day.